which you all are very familiar, having conducted your own practice analysis through the important CAPA working group. That practice analysis was very successful in outreaching to over 15,000 persons, both newly licensed lawyers and supervisors of newly licensed lawyers, to inform the kinds of things that newly licensed lawyers are expected to know and to be able to do as a bellwether for our subsequent discussions during phase 3 of our work with the testing task force, where we used focus groups made up of stakeholders, both in the academy and practice, service on the bench, who could provide us information about the appropriate blueprint for the future exam, as well as a design for the future exam, working from the science, the data gathered through the practice analysis, as well as that all-important feedback and information we gathered through our listening sessions. I'm not going to go through in great detail the substantial reports that were generated out of phases 1, phase 2, and phase 3 of our 3-year study. We also have a final report that was generated, and we have the preliminary recommendations that were generated from the testing task force. And we will talk in a moment about those recommendations. But I'm hoping, to the extent the significance and the detailed nature of the unencumbered and scientifically driven work of the TTF is valuable to you, that you'll take a moment to really take a look at those written materials, because they will underscore to you how seriously we took this work and how proud we are, frankly, of the recommendations that came out of this work, and the fact that they are, in fact, recommendations that are supported by the science and the information that we gathered. Those recommendations were presented to our board of directors in January of this year, and they were approved by the board of directors, which has led us to the all-important implementation stage. Next slide, please. The implementation stage has required the formation of an implementation steering committee that is comprised of both board members and, frankly, principally, the operational folks at headquarters who are significantly involved in actually now boots on the ground, operationally implementing the recommendations of the testing task force. This is no small undertaking, but I can tell you with assurance that the resources and energy and the interest is high and is completely committed to the success of the implementation of these recommendations. I can't really even describe to you the excitement and the dynamic that is building as we collaborate both with board members and with those at headquarters on developing the next generation of the bar exam. What I would like to do is invite you to take a look at the dedicated website that has been created for our implementation work. You see the site there. You are free and in fact encouraged to subscribe to that website, because you'll then have an opportunity to get updates about our work, because the same theme for collaboration, for an iterative process, to listen, to engage input from stakeholders that we had as a part of the hallmark of the TTF's work absolutely will continue during the 4 to 5 years we anticipate the implementation of recommendations to take place. The reference on this slide to known and unknowns refers to the fact that, as you might imagine, through 3 years of important work, we itemized and detailed a substantial list of things that are going to have to be done as a part of implementation, decisions that are going to have to be made, collaborations that are going to have to occur that we did not want to lose. And all of that has been captured and transferred to the ISC. And we feel very good about the structure of the ISC's ability to transition, frankly, with very little wasted energy or effort, straight from the recommendations approval to the first ISC meeting in early February. Next slide, please. The all-important structure of the work of the ISC is being captured in work groups that are led by our staff. And you see the identification of the 4 work groups here. These are purposefully not called committees. They are work groups, and they are hard working groups. We have a test development and psychometrician, or psychometrics work group. Psychometrics, of course, is the all-important science of high-stakes testing. Stated another way, you can't have high-stakes licensure exams without psychometrics, because psychometrics permit you to represent that an exam you've produced validly and reliably assesses applicants. Validity of referring, of course, to testing what it is you say you're testing. Reliability referring to the ability to measure over time in a way that is uniform. That is all about fundamental fairness. And we are in a position with the expertise at headquarters to assure that the next generation of the bar exam will provide that psychometric integrity required by the standards for high-stakes licensure exams. The dev group, as we refer to it fondly, will also be responsible for developing new item types, more about that in a moment, designed to create an integrated test experience. The work group on test delivery and operations, as you might imagine for any of you who've been involved in the administration of a bar exam, the list of topics to be addressed and dealt with involving test delivery and operations is lengthy, but we're on it. And we're already looking at all sorts of things, including the method of delivery, what that's going to involve, the computer-based component of that, what jurisdictions will have to do to make adjustments to the next generation bar exam, study aids, notice for applicants, notice to the academy so that you have fundamental fairness addressed there. I mean, it is just an unbelievable undertaking, but we have a great group focusing on those efforts. We have an incredibly important work group focused on diversity, fairness, and inclusion. And as that name implies, every single thing we do will be collaborated with and vetted through this work group, because we're looking not only at issues of diversity inclusion, but fundamental fairness across every applicant so that the exam experience is as uniform as possible for every applicant. One of the other all-important standards that you have to look at in terms of high-stakes licensure is trying to ensure fairness, which means trying to ensure as uniformly as possible the exam experience for your applicants. That includes accessibility, that includes ADA accommodations, that includes universal design principles. Again, the sky's the limit, but we have a focus work group on those issues. And then finally, we have a work group, kind of an umbrella organization work group focusing on our strategic outreach, coordination, and stakeholder communication. And as the name of that work group implies, we are committed to listening again, to reaching out to jurisdictions and to other stakeholders and making sure that our work is transparent, that we are sharing with you our progress, and that we are getting input from you along the way. All of this structure is designed to ensure that the recommendations are being implemented consistent with their intent, and that we are producing a next generation bar exam, again, that validly and reliably assesses applicants, and that continues to permit for a portable score to the extent jurisdictions are committed to that feature of the uniform bar exam. I can tell you that from February 1st until now, the hours that have been spent between the ISC meetings, between work group meetings, between work group lead collaboration meetings is into the thousands. That is not an exaggeration. And we're 6 months into an enterprise that we expect to take 5 years. But the excitement keeps building, and that includes for people like me who have a day job but really can't get enough of being a part of feeling like you're doing something that's the right thing for the right reason. Next slide, please. We talked a minute ago about those all-important recommendations out of the TTF that are now being implemented, and they follow these various topics that you see on the screen. The content recommendation is extremely important. We heard during listening sessions kind of a mixed bag. On the one hand, people complain that they think that there are certain practice areas, the area of law that someone practices, and what you've got to have that on the bar exam. And on the other hand, people complained or were concerned that too much is tested on the bar exam. And when you distilled all these tension points and looked at the science that came out of the practice analysis, and then went through our focus groups, particularly the Blueprint Development Committee, as well as the Test Design Committee, and you started to kind of hone in again on what is it that the purpose of the exam is, and how is it that, or what is it that you get from that bar exam by way of a general license. It was a bit of a light bulb moment, quite frankly. You can make a mistake with a bar exam, it seems to me, by trying to do too much and forgetting the lane that you are in relationally to those other features on the ecosystem of bar admissions. And so the extent to which a bar exam should be assessing foundational concepts and principles on foundational skills became a hallmark of our recommendations. I'll talk a bit more about what those are in a moment. Structure and format, also an extremely important aspect of the recommendations of the TTF. We have committed to an integrated exam design that will assess holistically knowledge and skills with a mix of item types and formats. That's a mouthful. What do I mean by that? What I mean by that is exam efficiency, both in terms of item development and item administration. What I mean by that is an appreciation that any particular component on an exam can and should have as a central feature an objective of assessing a range of knowledge and skills. And that to the extent possible, an integrated exam should attempt to utilize item sets that are a collection of items that refer to a common set of resources or a common stimulus, so to speak, and that can, from that collective common set of resources, generate through either the same or a variety of different item types, a number of questions or means by which an applicant can express information. The integrated design serves a valuable purpose because it has a feel of being more job related. It feels more like what a lawyer experiences. And you move away from these somewhat artificial, discrete components of an exam, and you move into an exam environment that an applicant should recognize feels very much like what they might experience when they get out there and practice law. Either, again, by nature of the fact that the item itself is designed to assess more than one thing, or because item sets are generated in a way that they feel like an environment that you might walk into if you're meeting with a client or with a senior partner or something along that line. There are other advantages to integration that get into psychometric things, and I'm not going to pretend to be a psychometric expert. I am not. But I do know from the things I've been told from those in the office who are psychometrically trained that you have more equating options available to you with an integrated format, and that is certainly a plus. We are really excited about where the dev group can go with an integrated exam design, and I'll talk about that more in just a minute. But the bottom line is you're still going to see multiple choice questions, you're still going to see short answers, you're still going to see essays, but the manner in which they are built, the feel of the exam will be very different, and I think in a very exciting way. You also see here that recommendations included the frequency of the exam, the scoring of the exam, and the timing of the exam, really which are unchanged from the current exam. With respect to the delivery mode, there is a commitment that has been made to have a computer-based delivery of the exam, either at test centers or on examinee laptops at jurisdiction managed sites. To be very clear, that is not the remote administration that was necessitated by the pandemic. That is not at all what we're talking about with a computer-based delivery. And to be equally clear, our fundamental objective with computer-based delivery is not to say, oh gosh, we've got this newfangled exam of the future, we're going to computer, but to recognize that by committing to a computer-based administration, you actually introduce components of fairness that you perhaps did not have before, particularly if we are able to find a way to ensure that this exam of the future can be administered at test centers. And we are looking extremely hard at that to ensure that the exam experience is uniform and that the manner in which the exam is administered is fair. We are open at this point to any and all input on that topic, but the bottom line of administering the exam by computer is a commitment that we have made. Obviously, we would remain committed as we would be required to and would want to in any sense to ADA issues with respective administration. So when we speak of computer-based, that is not to the exclusion, obviously, of any accommodations that might be required. Next slide, please. So what about those foundational concepts and principles? You see the 8 identified here on the left and the 7 foundational skills identified here on the right that came out of the practice analysis, the listening sessions, and many days of discussion with our blueprint development focus groups and our test design focus groups. And what you may not see on this black and white page here, but I want you to appreciate is that what ultimately became a decision point in where that cut line was with respect to these FCPs and foundational skills was a recognition that, again, what is assessed on the exam should transcend practice areas. Let me give you an example. Contract law transcends practice areas. Whether you are a family law practitioner, you are a estates and trust practitioner, a real estate practitioner, whether you're drafting a settlement agreement for your personal injury client, et cetera, et cetera, et cetera. Contracts transcend. Business associations transcend. When you're negotiating the property settlement agreement for your family law clients and you've got a husband or a wife who's involved in a business or their businesses owned together, business associations are an issue. Agency principles are involved with business associations. We wanted to identify doctrinal areas that are considered to be the core doctrinal areas because the principles that come out of those doctrinal areas are important regardless what you do as a lawyer. Again, what's the purpose of that bar exam? You're going to get a general license to practice law. The exam should be assessing within the confines of a general license to practice law, regardless of the practice area that you're going to be in. We heard as well, with respect to these foundational skills, a desire by our stakeholders to greater emphasize the assessment of skills. And when you look at this list, I wouldn't want people to panic and say, oh my gosh, we're going to have simulated clients and we're going to have competitions. That's not at all what's happening here. There is a place for the clinician and the role of clinicians in the academy with respect of assessing and teaching, frankly, clinical skills. And though there may be some overlap, the assessment we're looking at here is very different. It will be as objective as humanly possible. It's not going to inject sizable expense to the exam. It's not going to create fundamental unfairness because it's exposing people to non-uniform test materials, but it's going to feel real. And so, for example, maybe you'd see an item set where the context is the fact that I'm representing a client who's appeared at my office, and I have to figure out with that client what information I need to gather in order to make certain decisions that I'm being asked about with respect of the item types associated with that common set of materials. Or maybe I'm in a position where I'm negotiating a real estate contract for my client, and I'm given information that's going to require me to figure out a negotiation strategy or additional information I may need to obtain or acquire in order to reach a satisfactory outcome for my client. The assessment can be woven in the context of the doctrinal law. And once again, it starts feeling like what we do every day. If you go to the next slide, please. I'm sure it's probably of interest of you, given the significant resources and time that were spent on your own practice analysis, to get a sense of what the alignment is between the CAPA practice analysis and the FCPs and foundational skills that the TTF's recommendations have indicated should be assessed on the exam. And you see the 8 CAPA legal topics and the 8 CAPA competencies, which I think would be another word for skills, that were identified out of your work. I know a lot of work went into investigating the alignment, frankly, between the CAPA study and the practice analysis portion of the 3 phases of work that the TTF did. And I'm not going to get into all of that because I know you all have a detailed report that you generated, but I think it's fair to say that to the extent there were differences, they were largely attributable to different scales that were used or different task description, et cetera. But that on balance, there was a very high correlation between the legal topics or foundational concepts and principles or competencies, skills that were identified with your work and ours. Now, part of that shouldn't be surprising to you because there was a lot of cooperation, and I'm really proud of the fact that we've been able to work cooperatively with CAPA because your practice analysis was going on at about the same time as ours. And so there were a lot of California respondents to the NCBE TTF's practice analysis. So it's a good thing, frankly. You would have expected to see some alignment between the 2 studies. Next slide, please. Of all things that we heard out of the listening sessions, of all things that we heard, the thing that resonated the most with me was a sense, right or wrong, it doesn't matter, but a sense that the current exam, even though it's highly valid and highly reliable, determined to be valid by the 2012 practice analysis and very reliable by psychometric measures in terms of consistency of measure over time. Still, people felt like just the way the exam is structured, that there's a tendency of some of the questions to get too deep and maybe even to be too broad, and that too much is assessed on the exam. And so it's great that we've got these recommendations that have constricted the FCPs and have emphasized the skills that will be assessed on the exam. But all of that's really for naught if we aren't committed to a very substantial content specification exercise. And that is the very first thing that the Implementation Steering Committee is working on right now. We have in place with volunteers that have been solicited from across the country, a content scope committee that will begin meeting this summer and into the fall in a very sophisticated, I can't even begin to tell you how scientific the approach is and the protocols and the facilitation methods and the information and the data that will be used by this high-level content scope committee to drill down into every one of the FCP areas and each of the skills to begin defining the scope of what actually should be assessed within those topics, aligning that scope back to the practice analysis. That's called an alignment exercise, and that's extremely important to the work that you do. In addition, I think it's pretty important to highlight that what we hope to do through the content specs exercise as well is to identify where relevant the principal sources of law that the average newly licensed lawyer would need to go to if they were looking at a question on this topic or that. And as a part of that, to identify whether that is a source of law that would routinely be something you'd access every time because you just don't commit that stuff to memory, or whether there are basic concepts you would generally know, but you would still consult the book, so to speak, with respect to other information, because that's going to be extremely important to us as we move into test design, or excuse me, item development, in helping to inform the extent to which our items really require that an applicant walk in with information, or an applicant is provided with essential resources that then allow them to apply those resources to a fact pattern. Some people may call that open book. I call it somewhat open closed universe, but the recognition of more resources being provided as a part of the exam experience is absolutely an essential commitment on our part. And this exercise with respective content specifications will go a long way in helping to inform on that topic. We are going to be providing public-facing information as this work continues. And so again, I strongly encourage you to be a part of the website to follow that work as we go along. Next slide, please. And Justice, I see some hands up. Would you prefer I wait to the end to answer questions? Because I've got just a few more slides to go. Would that be the most efficient? Because we'll have plenty of time.
Yeah, thank you, Judge Martin. I was going to ask what your preference was. Do you prefer to just wait till the end and hold questions?
If you don't mind, because I'm getting pretty close to the end, if that's okay, and I'd be very happy. I've tried to build in at least 20 to 25 minutes for questions, anticipating that there might be several, if that's okay.
That would be great.
All right, thank you so much. I appreciate that. And I hope that's okay with those of you who have expressed interest with a hand raise. Hold on to that question, please.
Thank you.
Another important feature of the implementation obviously involves the development of item types. Now, I have to, say again, and as I repeated a minute ago, when I say item types, it's not like we're going to try to create a new universe here. When I talk about prototyping item types, it's really how those items are built together. And so, for example, will you still see some MCQs on this exam? Yes. But you're not going to see a day of MCQs known as the MBE. Will you still see constructive responses on this exam? Absolutely, you have to. That's the way we determine and assess whether or not people are able to express their analytical thinking. But the manner in which they appear may be very different from the MEEs or essays you see now, or the MPTs, the long form essays you see now. We are very early in our discussions about item design, or excuse me, test template, I should say, test design. But to say that we've already invested hundreds of hours in that discussion would not be a gross overstatement at all. But I would anticipate we're going to be looking at an exam design that gives us the opportunity to build modules around item types. And that whatever it is that is done, we are going to be looking at very sophisticated, scientifically steeped proof of concepts, pilot testing, field testing, prototype development, et cetera, all again designed to get us to that point of assurance where this new design is determined credibly to be both a valid and reliable measure of minimum competence of those items that have been deemed important by the content scope study for purposes of assessment of a newly licensed lawyer. You see some of the discussion here of what this will involve, because we'll also be, for example, getting into new item types to assess legal research, which is not something that is expressly assessed on the current exam, although it's somewhat woven into the MPTs on the current exam. Again, as a part of our commitment to collaboration and to transparency, we are going to be releasing sample items and item sets as they become available, and you should be watching for that. That should be exciting stuff. Next slide, please. I've already mentioned to you that we've made a commitment to computer-based test administration, either at jurisdiction managed sites or at testing centers. We are very deep in the important discussion internally of the kinds of things that will go into that decision. But I just want to emphasize again that that is a commitment we've made. Next slide, please. In addition, we are going to be looking at important things along the lines of notice and fairness to our applicants. This is just one example. We will be able, from the development of item types and a prototype, to generate not only detailed content specifications, as I mentioned a moment ago, but sample items that can be released periodically, and study aids for candidates, which frankly we already do. We have a wealth of study aids available for candidates that are very, very low cost and readily accessible, and they continue to grow by leaps and bounds in their quality and the nature of the functionality they provide to applicants. And that is a commitment we will continue with the next generation of the exam. Next slide, please. We do anticipate, because this is a new exam, that a new scale will have to be developed for the exam, and that will require some sense of standard setting. We will be committed as an organization at an appropriate point in this process to conduct a standard setting exercise, recognizing full well that jurisdictions retain and should continue to retain, if they wish, the desire to make their own policy decision regarding a new passing score within a range deemed appropriate by an overall standard setting exercise. Next slide, please. And finally, as I get to this question, I just want to sum up by telling you this. I have talked for roughly 35 minutes on something that's going to take us 4 to 5 years, and that followed 3 years of work. To say that this is the Reader's Digest version would be an understatement. And I tell you that because I have a great passion for this, but I don't have all of the answers. I'll do my very best to answer your questions today, or to direct you to someone who can, or to get you the information you need. But what I want to tell you is this: I recognize you all have some big decisions that you're going to be making and a lot to talk about. I think my role here is to just give you a sense of what the option is that's available to you in terms of the next generation of the UBE, and to commit to you the continued collaboration that we have shared for many, many years, and the access to the resources that we can provide you as you continue with your work over the next year to year and a half. So I hope you'll take me up on that, and I'm sure our president, Judy Gunderson, would echo the fact that we remain a resource to you and want to be available as you make difficult decisions with any information that we can provide. But we will have a 5-year roughly exercise here, with collaboration along the way with our work groups, with collaboration with our stakeholders, committed to fairness to applicants, committed as always to compliance with the standards for high stakes licensure exams, and commitment of the resources required, quite frankly, to undertake an adventure, and I call it that fondly, of this volume and of this importance. So with that said, let me see if I can help you with any questions that you have. And Justice, do you want me to simply call on hands as I see them raised, or do you have a different protocol that you want to follow?
That would be great. And I wanted to thank you for providing, well, first for agreeing to come and speak with us, and for providing all of that detailed information and your enthusiasm. It's nice to see, especially given all the work that you've already done, that you still have the energy to keep going. So it would be great if you would like to call on the people who have questions. Thank you.
And I'm not seeing full names here, so please forgive me. But Judge, I see your Judge Reiser. Is that correct? Reiser or Reiser?
That is correct. Both
Great.
of
You were
those
with
are
the
correct.
correct?
So Judge, thank you for being here. That's
My
really
pleasure.
helpful, and thank you for your hard work on the UBE. I know that those extracurricular activities are, they're uncompensated, but it's rewarding in a different way. I'm really glad you're here, because I have some questions which are a bit collateral, but it's within your unique expertise. So I just have 3 really quick questions, if you don't mind. The first one is, as as a prominent judge in Missouri, right? If you have a lawyer who's practicing in Kansas City, Kansas, and they're licensed in Kansas, and they want to practice in Kansas City, Missouri, right across the river, you don't make them take a whole new bar exam, do you? Isn't there some reciprocity that Missouri uses to allow those people in?
Yes. Sadly, not when I became a licensed lawyer. They had reciprocity and then got rid of it. And so I'm kind of exhibit A for, wow, that really stinks, because I had to sit for both bar exams, even though my court is as close to the state line in Missouri, Kansas City, Missouri, as you might imagine. But yeah, and I think, Judge, reciprocity, of course, refers to a recognition that a certain amount of active practice of law translates into a measure of competence that should be recognized by another jurisdiction. But yes, we do have reciprocity.
Thank you for that. So my second question, of course, Google is everyone's worst enemy, but it says in Missouri, applicants, the exam doesn't test candidates on state specific law, but applicants must sit for the Missouri educational component before they can take the actual bar exam. So I was just curious, what is that?
Well, it's really it's an exciting tool that Missouri, first of all, let me back up. Missouri was the first state to adopt the uniform bar exam. And I happened to be president of the Missouri Board of Law Examiners at that time. And so I've been drinking this purple Kool-Aid for quite a long while. But, as you might imagine, with something that was a fairly new concept with the UBE, and this notion that we would be moving away from state-specific essays, there was an appreciation by our court that, okay, if we're going to count on the bar exam and the people who know what they're doing in terms of psychometric measurement to develop an assessment tool that meets the standards for high stakes licensure and that is valid and reliable, is it really essential that we duplicate that work with state-specific information, particularly when there are only so many hours available in a bar exam, and there is no way in the world ever that you can assess people on everything that you might think is important to state-specific. But what you can do is add a state-specific component that does not factor into the bar exam score, but that becomes something else, kind of a checkoff item that applicants have to have completed. And what we did in Missouri is we came up with really detailed outlines across a number of different substantive areas, including, for example, areas you would never test on the bar exam, like our structure of judges and courts in the state of Missouri, for example. And we focused on those outlines on the things that make Missouri law unique. As one of our justices on the Supreme Court in Missouri put it, the goal here was to generate materials that keep someone from backing into a buzzsaw, not to test their readiness for practice, but to expose them to the information that you would want them to know if they're going to practice in your state. So that becomes a resource, frankly, that's accessible by every lawyer in the state, but has to be studied and looked at by someone who wants to be licensed in Missouri. And then they take an exam. It's a kind of multiple choice exam, kind of like a driver's license test, frankly, online, and they have to get 75% right. But it doesn't generate a bar exam score. It's designed to assess exposure to information.
Thank you for that. And my last question is, so the July, September, October 2020 bar exam in Missouri had an 84.2% passage rate. Do you feel that you're not protecting the public by allowing in lawyers, or because I mean that is that's a significant number of people, but California has never done that. And my instinct is that perhaps we ought to be a little more like Missouri-ish in some of these instincts.
And by that, do you mean a percentage of passing that's closer to the percentage of passing in Missouri? Is that what you're getting at,
well,
Judge?
I mean, do you feel that so many people are coming into the bar that there's one of the goals, obviously, of the bar is to protect the public, right? Do you think that so many people are being allowed in that the public's not being protected?
No. I don't, because I think we feel very confident that the credentialing model we have, including the quality of the materials we use for the bar exam, provide us with a comfort zone that the right people are becoming licensed, and those that don't the first time often do the second. If you were to look at the pass rate for second time takers, and honestly, it is not that the bar exam is meant to be an obstacle to admission, but there is something to be said about a recognition of the value of the license. It's not just something you go pick up at the grocery store. It means something. It should mean something to us, but really what we should be more concerned about is what it means to folks out there who are clients. They expect that license to mean something. And so the rigor associated with going to law school for 3 years and doing well, and then sitting for and passing a bar exam, demonstrating character and fitness, all of the things associated with licensure should mean something. Do I think we have too many lawyers being admitted in Missouri? No. Do I think we have competent lawyers being admitted to Missouri? Yes. And the folks who do not pass the first time, who pass the second time, you know, maybe they didn't focus the way they should have, but I bet they'll be more competent by virtue of having to realize, wow, I really need to prepare myself for the practice of law.
Thank you, Judge. Appreciate that.
Thank you. Mr. Harrison?
Yes, thank you, Judge. I think I have 3 questions for you. The first one, I think you may have answered in your presentation. I know you're presenting on the future direction of the UBE, and the thought came to mind like, well, is this commission going to be able to recommend adoption of the UBE when you don't have a finished product that we could assess and you know, digest to even consider and make that recommendation? And it seems that you have a 5-year timeline on this when our Blue Ribbon Commission has a 18-month timeline. Is that correct?
We have a 5-year timeline for purposes of the likely first administration of the next gen exam, but I would reckon that within the next 12 months to 18 months, you're going to have a pretty good sense of what we're looking at in terms of test template and item types. It won't be final, but we expect, I would think, within no more than a 3-year, probably closer to a 2-year timeframe to have a pretty good sense of our content specifications and overall test template. But
Okay.
we certainly won't be in a position to administer that exam for a while because there's a whole lot more that goes into it than that.
Thank you. My next question has to do with the MBE specifically.
Yes, sir.
And I know this might be premature, but can you give us an idea of what types of significant structural changes to the MBE that are currently on the table for you guys?
That's kind of a loaded question, so I want to make sure I'm interpreting it correctly. When I think of the MBE, I think of a full day of MCQ questions. That will not exist, but MCQ questions will remain a part of this exam. And so I could foresee, and this is definite soothsaying here, this is, don't quote me on it because we're still early in the discussion of what the modules or test design might look like. But I could definitely see like maybe, you know, short blocks of the exam, maybe an hour here or an hour there that are focused on MCQs, but that the feel and look of those MCQs would be different in the sense of kind of an integrated concept, what it is that they're designed to assess. I also could see that to the extent item sets, which is the word I'm using to characterize when you are provided with a collection of resources and then a variety of different item types might be asked around those resources. I could most definitely see MCQs being a part of that. So to ask me whether or not the MBE will remain, will there be a full day with 200 MCQ questions as a discrete component of the exam? No. Will there still be MCQs on this exam that look like the MBE type MCQs? Yes, though the scope of their coverage will be greatly influenced by the content scope committee work that I described for you.
Okay, thanks. And my final question has to do with issues of legal practice that I experience as a litigator in California specifically. I mean, we have to worry, like when I want to file a dispositive motion, we have to worry about the Code of Civil Procedure, the Judicial Council rules, and the local rules of the court. You know, sometimes you don't need a separate statement for a motion for summary judgment in the Northern District, but you do in the Eastern District. And how is the UBE going to test those type of skills for new attorneys or attorneys trying to practice in our jurisdiction of where to go and how to look up these different rules so that they don't make a mistake that could be found to be malpractice?
Mr. Harrison, that's such a great question. And it really underscores, I think, kind of a philosophical view of the bar. Because, you know, one of the things I think people criticize a bar exam about is, does it require a bunch of memorization of tedious rules? And you don't want that because that doesn't really assess much of anything. The skill you've described, The ability to know as a lawyer that if I'm practicing in the Northern District, there are local rules and I need to go read them. That's the skill you want to assess. The memorization of those local rules gets you nowhere really, but we've faced frankly the same in Missouri. Hard to believe in Missouri, we do not have codified rules of evidence. Can you imagine that? We don't have codified rules of evidence. Evidence is totally common law in this state. And that is so foreign for most jurisdictions, certainly if you're exposed to the federal rules of evidence. But do I feel like a lawyer who takes the UBE in Missouri is not competent because they aren't tested on Missouri non-codified rules of evidence? No, because that's what one of those outlines on state-specific evidentiary rules is permitted or allows an applicant in my state to be exposed to. So I guess the long-winded answer to your question is I don't think you need, for purposes of public protection, to assess an applicant's knowledge of every local rule or state-specific concept. I think what you need is an assurance that lawyers have the skills to appreciate those are things they need to go find because they are local or state-specific, and that they have the generalized foundational concept and principles, in their toolkit to appreciate that deadlines mean something, for example, or what do these words mean with respect of affidavits, et cetera, so that the foundational concepts that transcend application into particular practice areas can be assessed.
Thank you.
Thank you. I don't know if Mr. Gupta or Ms. Rodriguez had their hand up first, but if one or the other of you want to go next, I'm sorry, I didn't notice who raised their hand first.
Ms. Rodriguez had her hand up first.
Okay, thank you, Ms. Rodriguez.
Thank you, Judge Martin. So I think I know the answer, but I want to make sure.
Sure.
With this new UBE exam, does that mean that the separate parts of what make up the UBE exam will be discontinued? In other words, a jurisdiction like California could not say that we wish to continue as is and only using the MBE exam, but keeping the other two parts.
It means the exam as it looks today will not continue to exist. But since I can't tell you precisely what the new template's going to involve, that's a hard one to answer. But it would not be fair to tell you that we are not fully aware that you and other jurisdictions have come to depend upon a discrete component of the exam like the MBE against which you do your scaling. We understand that. And though we believe that this new integrated exam, which will be built up of various modules as I've described, is designed as a cohesive unit to produce a valid and reliable score, we are committed as a part of our 5-year work plan to work with jurisdictions like California for a solution to that quandary. One of the things, and I'm not even going to try to talk about it because I didn't stay at a Holiday Inn Select last night, so I'll come off as a fool, but I know enough to know from the psychometricians that I've been honored to work with over the last 4+ years on this project, that there are more ways to scale than just by anchoring to multiple choice questions. And so give us a minute. Let us do what we know we can do to get you what you need to provide that kind of context for your exam. And in the meantime, you're going to have the same essential exam with very few tweaks over the next 4 to 5 years, against which, should you decide to administer that exam or something like it, to equate against. But I recognize the point of the question and just know we are working on that and understand your concern. Mr. Gupta?
Hi, thanks again, Judge Martin, for your presentation. If I'm not intruding too much into the secret sauce of this new next gen bar exam, I'm wondering how does NCB intend to pre-test some of the new design concepts? Are they going to be added to upcoming components of the UBE or the multi-state performance test? Or is this going to be some sort of volunteer testing of individuals? Is there a plan in place for that?
The plan has not been settled upon yet, but I so appreciate the question, because for every question like that, there are like 100 others that we are collaborating about. And what I can tell you is there will be a plan for pre-testing. It may involve some sort of volunteer testing. We have some incredible incredible minds at the table at headquarters, including individuals with psychometric and other experience who have been involved in test redesign in other contexts, not the bar exam, but other high stakes licensure or standardized testing. And they have some fantastic ideas for us. And so as we're grappling during this first 6 months, working on kind of a high level critical path method timeline for our work and sort of plugging in the critical pieces of that, which include things like pre-testing, we're grappling as well with what does that look like? How should it be done? How do you assure that the way that it's done is done in a way to generate good data so that you are actually able to rely upon the information that you gather? And we do have plans. We have thoughts. They're not finalized, but I can assure you that that is a part of the strategy we will be working on.
Okay. I did have a second part.
Sure.
Or a completely different area to ask about. So New York State has had its own task force
Yes.
evaluate the its switch to UBE. And I guess they've issued reports that are somewhat critical about the UBE because I guess they're hearing anecdotally reports from judges saying that folks that newly enter the New York bar are not really knowledgeable about New York law. And so I think this sort of highlights a tension here, right? Are we testing the minimal skill level and competence to be an attorney? Are we testing the minimum skill and competence to be a California attorney or a New York attorney? So you've already hit on some of those issues a little bit, but is there something unique about California that makes it more like a New York in terms of its body of law and how different it is from other states?
Well, with all due respect, I think that question presupposes that there's something really that unique about New York. And I do not mean that in any way disrespectful, because I understand there is a lot of room for disagreement and for differences of opinions on these topics. And so I'm very respectful of the viewpoints that some feel so strongly about that are reflected in the New York report. We're obviously just seeing that at the conference level. And I thought it kind of curious, frankly, Neil, that you used the word anecdotal, because a lot of the discussion in the report is, at least it comes off as being anecdotal and not really grounded in kind of scientific data, but it is what it is. And I think they are impressions that one must contend with. But at the end of the day, you know, it is a policy decision. We live in a world where many times law students, they don't even know where they're going to get a job. They don't know where they're going to practice, or they may start practicing one place and they may have to go someplace else a year later because their family moves, or their wife gets, you know, deployed someplace and is going to be at a base in, you know, some other state. And so when you're balancing competing issues of fairness for applicants with the importance of public protection, what is the best balance? That's an answer that you have to arrive at. But it strikes me that the best balance is to assure that if I have a license and I'm going to be in a position to move that license to another jurisdiction, whether it means I have to set for another exam or go through just an application process or whatever it may be, I want to be able to assure you that I know the basics. And if the state I'm going to has a plan in place to expose me, not because you need to do it validly and reliably through a high stakes instrument, but because you want to expose me to the things you think are so critical to your state that without which that exposure, I won't be a competent lawyer in your state. There are a lot of ways to accomplish that don't require becoming parochial in terms of a state-specific bar examination that purports to, you know, decentralize what's becoming really kind of a uniform practice of law in a global economy. It just seems to be almost a backwards parochial view to approach it too stridently in that respect. And again, I don't mean that disrespectfully. I understand there are strong views on both sides of that issue.
Sure.
Judge Martin, I had a question, if
Sure.
I could ask without raising my hand, if I could do it
Sure.
the old-fashioned way. I was curious about the thought process in going to a computer-based testing, and I'm right now around older people who to them it would sound difficult to do that, and maybe, you know, younger attorneys in law school would have the opposite view. And I was just wondering if you've had any feedback on that, and also if that's locked in, the parameters of that, as an example, would they be able to have documents or something printed as well, or the ability to maybe outline something if they're doing a writing exercise? And if none of that is available, is there any concern that that might increase the request for accommodations?
That's a great question. The feature that's, I think, locked in is the notion that you're going to be answering everything on a computer and that the test materials largely would be on a computer. The parameters where it gets a little fuzzy, and there are things that we're still going to look at, again, relying heavily on that all-important diversity, inclusion, and fairness work group to provide us some input, are what would be permissible practices. Can you bring in scratch paper, for example? If we make a decision with respect to certain content areas about resources provided, could some of those resources be brought in? We haven't ruled any of that out. We haven't ruled it in, but I don't think those kind of fringe issues are inconsistent with the commitment to computer-based testing. And you kind of have to keep in mind that, frankly, for most jurisdictions, I mean, the MBE at this point is answered by computer. And although you do have the questions in a paper form, the notion that the questions on an MCQ would be available on screen is not going to be that foreign a concept, I don't think, to most applicants. For most applicants, not all, but most now answer their essays on computers. So the provision of the answers by computer is kind of a no net change. It's just this sense of the real estate on the computer screen also being taken up with the materials themselves. So those questions that you're asking, I mean, those are the exact kinds of things we're going to want to seek input from stakeholders about and get a sense of, what's really the will of the group to the extent it fits within those parameters, with the abiding objective to be fairness. And I do understand the concern that the last thing anybody wants is to unnecessarily increase accommodation requests. But obviously, to the extent those are legitimate accommodation requests, those are going to be accommodated. They have to be, and they will be. I hope that answers your question, Justice. So.
It does. Thank you very much. And again, thank you for the wonderful presentation. I don't know if there are any other questions for Judge Martin.
Just let us help you. If you think of anything after the fact, you know where to find us. Please reach out. We'll be very happy to provide you with any information that we can. And I really appreciate your time today and your attentiveness and for letting me prattle on about something that I care deeply about. Thank you.
Thank you again. We'll go ahead and take our I think there is a 10-minute recess in the agenda right now, and reconvene at 2:40. Good afternoon, everyone. We'll go ahead and recommence the meeting. And the next item on the agenda is a presentation about the testing considerations, which will include a discussion of various question format and delivery methods. For this presentation, Tracy Montes will be presiding, I believe, and I'm not sure if also Donna is going to be participating.
Oh, Justice, I'm going to be giving a couple of opening remarks to the group before Tracy comes on.
Okay, thank you, Amy.
Sure.
And I didn't know if Donna was going to be joining or not. I didn't introduce her earlier, but I wanted to do that at this point. If she's on, I'm not sure. I just didn't want to continue that oversight. I wanted to thank her. She is, as you know, the interim executive director of the State Bar of California, and she has been instrumental in the preparation for today's meeting, as well as Amy. So I'm not sure if she's on, but I wanted to thank her. Amy?
She is attending business and she will be right back. She has
Okay.
a call she couldn't get out of. All
Okay,
right.
thank you.
So far today, the commission has been provided a basic understanding of the current construct of the bar licensing in California. What is required for licensing? What does the exam look like? Who is successful on this exam, as well as who is not? What skills, abilities, and knowledge sets should the State Bar be testing? What is tested on the UBE? And as a UBE morphs, what is it aspiring to test? The Supreme Court has also asked this commission to explore examination alternatives. Are there other question formats that are more applicable for entry-level attorneys? What are they? How should candidates be tested? Is twice a year sufficient or not? Is open book appropriate or not? Should the State Bar continue with online examinations? And how do other licensing programs determine their testing method? With us is Dr. Tracy Montes, who will be presenting on these issues. She mentioned this earlier, but she's the Chief of Division of Programs and Policy Review, Department of Consumer Affairs, appointed in February 2016. With that, I will hand it over to Dr. Montes.
Great, thank you, Amy, and thank you, Justice. I again appreciate the opportunity to present at the first Blue Ribbon Commission meeting. And as Amy mentioned, I'm going to be giving you a perspective from the Department of Consumer Affairs. I am going to repeat some of the information that's already been covered, emphasizing some very important points and also drawing some parallels and some differences in terms of what we do at our department. But if you could turn to the next slide, please. These are the topics I'm going to go over. I'm going to talk a little bit about our department, those regulation guidelines and standards that the work we do adheres to, a little bit about a purpose of a licensing examination, again, emphasizing the other points that have been made in prior presentations, talk a little bit about examination formats, delivery of exams, and then some examples of our programs here at the Department of Consumer Affairs. Again, I'm going to stay at a very high level because there's so much information with regard to each one of these topics. I could spend hours and hours. So I believe the intent of this meeting is really to introduce you to some points to think about to help facilitate future discussions. So with that, we'll go to the next slide. For those of you who are not familiar with us, the Department of Consumer Affairs, we protect and serve Californians by administering more than 3.9 million licensees in about 280 license types. And this is all within about 37 boards, bureaus, programs, committees, and commissions. And so we do this primarily by issuing permit certificates or registrations through licensing. And then we also provide enforcement of these different license types. And we do it mostly with individuals, but we also do it for some establishments like barber and cosmetology through their establishments. But we're a very big organization. We have an executive team that's like an umbrella that works with the various boards and bureaus providing support services. So really it's the boards and bureaus themselves that have the laws and regulations that guide these particular professions, but we are the umbrella to help support them meet that mission. The next slide. So this is a very unique unit to our department, and there are other states that have similar units like this within their departments that regulate professions. Ours is called the Office of Professional Examination Services. This is where I grew up. I started as a graduate assistant, did my thesis on a passing score for one of our boards, and I've continued to utilize my knowledge and skills to help our boards and bureaus with their missions with regard to exams. So our unit, and we've worked a little bit with Amy and her team, but we provide consulting services in examination, validation, and development to our boards and bureaus and committees. Not all 37 boards and bureaus, but many of them. They all have different types of exams they use. Some are state, some are national. So we're involved at different levels with each of these boards and bureaus and committees, and I'll explain a little bit more later. But what we do is we make recommendations in addition to the actual work we perform based on regulations, professional guidelines, and technical standards related to licensure examinations. And really, OPS's role is to be objective and neutral. So this is something that's really different and valued within our department because we can step in and we're not looking to make a profit. We have contracts with our programs, but it's not so much as a private vendor that may be looking at their bottom line and have, overhead and things like that that they have to charge for. So they have to sort of balance maintaining their business as well as working with various clients. We, however, are in-house and we can be very objective and neutral because we don't necessarily have a lot of the costs and expenses that a private vendor would have. Next slide, please. So these are the regulations, guidelines, and standards that we follow at Consumer Affairs. And you heard these many times in the prior presentations that were given. However, what is unique to the Department of Consumer Affairs is Business and Professions Code Section 139. I'm very particularly proud of this one because back in the 90s, the California legislature found that adhering to those professional guidelines and technical standards were so important that they put it into this Business and Professions Code, which mandates our boards and bureaus and committees and so forth to adhere to these standards. So every year we produce a report that shows the extent to which our boards, our programs, I'll just call them from here on, have done their practice analysis, how they're doing their exam development, the costs that are associated with that. So they have to adhere to these to the best that they can, and we facilitate that. And again, that professions code, Business and Professions Code, is based on the principles for the validation and use of personnel selection procedures, the standards for educational and psychological testing, again, which you heard a lot about, and also the federal uniform guidelines for employee selection procedures. This one you don't hear as much about because it's a federal document and it focuses a lot on selection, but it also has to do with adverse impact and so forth. So we look at all of these resources, and I know I've used acronyms and I can spell those out for you later, but they're essentially research-based types of standards and guidelines that we apply to testing. And something that I'd really like to point out too, that most people don't realize, but when we talk about testing, even an interview, a job interview is considered a test. And the standards and guidelines that are outlined in these documents apply to all types of tests, whether it is a regulatory test like the bar exam or a firefighter's test in Kansas or a clerical exam in New York. These standards are what the courts will look at when they're looking for guidance on validity, reliability, and so forth. So it's really important that we explain to individuals this isn't unique to California, or it's not just unique to licensure exams, but it applies to just about all exams. So moving on to the next slide. The purpose of a licensing exam, again, which we've talked a lot about, is to protect consumers. So DCA works with our professions throughout California to protect consumers from unlicensed practitioners. A licensing exam is a mechanism, and I should point out one mechanism to protect consumers from harm, and it's used to assess competency to practice. So what's really important to keep in mind is that we're talking about a high stakes examination when we talk about high stakes, where the consequences of a wrong decision could result in great harm. And so that's why our exams, our licensing exams, we have these standards to follow. That's why we focus on security, because we want to make sure that we are implementing a reliable method for identified practitioners who are able to practice and safely and competently. If it doesn't matter whether or not we do this purpose, it doesn't have to be high stakes. It could be something else. But when we have a high need to protect consumers, then we have high stakes. And we also focus on entry-level tasks and knowledges. Again, you've heard that before. Why do we do that? Because that's our standard for high stakes licensure exams. And I'll tell you, that's one of the most difficult concepts that we run into when we do our licensing exams in California. We work with subject matter experts who are licensees in their respective fields. So if we're doing a psychology exam, we bring in psychologists and we work with them to develop the exam and to set the passing score. And we work very hard to focus on entry level because most individuals don't want to work with entry level. They want stars. They want individuals who are going to shine in the profession. So we have to remind them that the standard for licensure is entry level. It's also referred to as minimum competency or minimal acceptable competence. We spend a lot of time talking about what those individuals have to do to get to that level. Again, depending upon the profession, they may have education requirements, they may have supervision requirements, they may have additional testing, but there's usually several, I call them hurdles, that have to be met in order to get to that licensing exam. And then we have this entry level standard that they must achieve. Now, again, the reason why I talk about entry level and really emphasize this is because there's also an assumption, often by the public or candidates or schools, that licensing is a mechanism to gatekeep. It is not. In fact, the standards for educational and psychological testing specifically state that a licensure exam should not restrict entry into the population or gatekeep for something other than competency. So we don't, again, there's a tendency for individuals to think that we adjust the passing score because we're trying to reduce entry. No, if you have 100 candidates and they are all qualified and competent, then all 100 should pass that exam. But we know that that's not the case and not everybody is equally qualified. So again, the purpose is to protect consumers from harm, to use as a tool or a mechanism to make these pass-fail decisions. Next slide, please. So what needs to be assessed? That's the very first question that you want to ask. And we discussed that, or that was presented with the California Attorney Practice Analysis. And that report was provided to you. And those very important knowledge, skills, and abilities and tasks were presented. Now, the idea with a practice analysis, again, which we really tried to explain to our subject matter experts, is that it is a snapshot in time. The uniform guidelines suggest that we do this about every 3 to 7 years. 5 years is kind of our average that we recommend with our boards and bureaus. You want to take a look at the profession every 5 years to see what's changed. Some professions it changes quite a bit. Technology, new materials, methodology. Other professions, it doesn't change quite as much. I will tell you though, with most of our professions, we see a lot of changes in laws over the 5-year period. So it's really important to take a snapshot about every 3 to 7 years, average 5, depending upon your profession. Take a look at it and see what's going on. Okay, your practice analysis is going to be a huge snapshot of the scope of what's being done. From that, you have to whittle it down to the most critical tasks and knowledge, skills, and abilities to assess. That's probably the second most difficult thing to do, besides setting a passing score, is taking everything that everybody thinks that students or candidates should know and do in the profession and saying, okay, what is most critical for entry level? What can we test? What is reasonable? Because again, most of our subject matter experts would say, we want them to test for a week. We want them to do essay tests. We want them to do multiple choice tests. We want to do performance. We want to make sure they know it all. We can't do that. So we create an exam outline, a test specification, again, different names, but it's essentially sifting out what is most critical and then focusing again on that entry level. Next slide, please. Okay, so how do we assess those tasks in KSAs? You've identified you've got a high stakes licensing exam, you've done your practice analysis, you've got your T's and K's, you whittled that down to that critical knowledge base. Now you need to determine how best to do that. Well, the first question you want to do is go, what else is required to become licensed? Does it have to all be assessed in the test? So we talked about other types of tools that might be used. One trend that we're seeing with some of our boards is instead of having a California specific law exam, they're going to an open book California law exercise. Some of them are calling it an exam, and I'm having to gently remind them, if you call it an exam, you're still going to need to meet all these technical guidelines and professional standards and so forth. So let's really think about it. Is it high stakes? Is it low stakes? And so they're determining that because laws change and you might go and look them up, that it's okay to have an open book test, but yet there's still some very critical competencies that need to be tested in a more traditional high stakes format. So again, we're seeing some different trends. So you really need to take a look at everything that's in place: education, supervision, if there's some kind of on-the-job pathway to licensure, you need to make sure that all of those requirements are weighted and thoughtful so that they don't become a barrier to licensure, and that you don't use the exam as sort of the catch-all, the last chance. And again, that's something that we remind our boards often, is if you're going to have these other pieces in the licensure process, they need to be robust too. You can't just say, we're going to have this exam and it's going to catch everything and everybody. We're just going to, lump every topic, every competency in it, because again, that's really not fair to the candidates. So you have to take a look again at the big picture. In those discussions, you go into what is practical and fair. Is it reasonable to have somebody be assessed all day long? Is it reasonable to have them come over multiple days? Travel, again, you heard this in our earlier components, balancing protection of the public to a reasonable and fair assessment of competency. In those discussions, you also talk about the format and the type of the exam questions. I'll talk a little bit more about that in some of the other slides. What delivery method should be implemented, because that's going to impact what's practical and fair. And so a lot of the questions that we'll be considering over the course of this commission, they're all interrelated. And so just keep that in mind, because the decisions you make for one is going to impact something else. So how you decide maybe to the types of questions you may choose to do could impact what kind of delivery you do. So lots of questions. to consider over the next 18 months. The next slide, please. Okay, so I'm just going to mention 3 of the most basic or common examination formats, and I'm going to talk very briefly about their advantages and disadvantages. Again, lots of research with all of these different types of exam formats. I have advantages, disadvantages. They could also be called strengths and weaknesses. But we're familiar with oral or structured interview type exams. Where you would go in and you would be given a list of questions to respond to. Those are the more psychometrically sound. The unstructured oral interviews where you just go in and talk, that's not very valid or reliable or defensible, so I don't even have that on here. But way back when we had the Board of Behavioral Sciences and the Board of Psychology, they had oral exams as part of their process because they're clinicians, and so they wanted to simulate that type of exam format. They no longer do that. We found, as we knew, that there's a lot of error involved in that measurement, rating error. It's very expensive to administer, a lot of problems. And so we came up with an alternative, which I will talk about later, but that's an oral or structured interview. Again, many of us are familiar with that when we do job interviews. There's also clinical, performance, and practical exams. A good example of a performance exam is fire engineer, where you have to learn how to drive the fire truck, you have to know how to lay down the hose, pump the water, all of that. That's a little hard to test in, say, a multiple choice test question. You've actually got to perform that. In consumer affairs, we have the registered dental assistant that has had a clinical exam where they would actually bring in subjects and do a series of cleanings and various exercises, test exercises. And again, they are no longer doing that anymore because of some issues with standardization and rating and so forth. But again, they've got some alternatives in place. And then of course, the one that we are most familiar with, and that's a written format, whether it's paper and pencil or multiple choice as we would call it, but a written type of test. So let me talk very briefly again about the advantages and disadvantages. That's on the next slide. And a lot of these are intuitive. With your oral structured interview, clinical, performance, practical, you have that face-to-face contact with the candidate. You can ask follow-up questions as long as they are in a structured format. You can simulate client interactions. This means high fidelity. Again, I use the example of Board of Behavioral Sciences where you could simulate having a counseling session. Disadvantages, though, is that they're very costly to develop. They're costly to administer. They're susceptible to rating errors. Even though you train your raters on how you're supposed to rate and score, everybody comes in with their own expectations, and it's really hard to remove that error out of the process, that measurement error. Also, standardization issues. Standardization is another psychometric term that we like to use. So you'll hear validity, reliability, fairness, and standardization. And that's the idea that everybody receives the same kind of testing situation. You know, so they have the same amount of time to prepare, the same amount of time to respond. It's a very similar experience for the candidates across the test. Another disadvantage is it's very time consuming to administer these exams. You can imagine if you're doing some sort of performance or practical exam. Reduced opportunities to examine. You may only be able to afford as a regulatory agency to do something like this maybe 2 or 3 times a year versus other types of exams. And then often you have delayed candidate results. Again, you have to take time to score and evaluate each of these candidate performance, you know, or tests or grading cards, whatever you have in your that you're using. It takes time, which is why we often do things like a written format, which is the next slide. And again, this was mentioned in earlier presentations, but they tend to be less costly to develop and administer. They tend to be more efficiently scored and reliable. Again, tend to be more standardized. And believe it or not, they can be appropriate for testing higher order cognitive achievement, such as problem solving and so forth. They can be very thorough and representative in sampling of the content. So if you have a large exam plan where you're trying to test a lot of areas, competencies, you can usually get through that quickly with a written test. Often convenient for candidates. And again, depending on the question type, you can have immediate results for the candidates. Let me go back and talk a little bit about these advantages. There's been discussion and so forth about whether or not you can really test what we call higher order cognitive processing. So when people think of written formats, they think of typically multiple choice tests, which again, we're going to talk a little bit more on the next slide. Most of us are familiar with the tests that we took in elementary school or junior high, even the DMV. Sometimes we think of those types of questions, but we've come a long way and we have the ability to write some pretty thorough analytical types of questions. And so again, I'll talk about that more on the next slide, but it's definitely become an advantage for written formats. Disadvantages, typically no face-to-face contact with candidates, inability to do follow-up. Sometimes you can have flawed items in your written tests and they're a little bit more difficult to deal with. If you're not savvy at writing test questions or putting tests together, you can clue the candidate. Sometimes you'll find answers to questions. It's always one of my test taking strategies. If you're stumped, look through the test if you can go back and forth items, because you might find the answer in another question. Also, here's another biggie, tendency to write trivial or recall items. This goes back to, again, our history or experience of multiple choice written formats is they're usually easy. I call them factoids, trivia type stuff. Those are not the kinds of questions you want in a licensing exam. You want something that really requires thoughtful thinking and preparation. And again, talk about that more in the next slide. Sometimes you can have random guessing effects, and then obviously written formats are not good for measuring psychomotor skills. So again, really went quickly, sorry about that, on the different formats, the basic formats. I will tell you at Consumer Affairs, we are moving away from oral exams and clinical exams for the reasons of those disadvantages that I talked about, the expense, the lack of standardization, the lack of reliability. We're finding that our schools and our training programs and our supervisory programs are doing a really good job of dealing with that, addressing that. And so they're getting that earlier in the process. So why do we need to duplicate that? Even with our registered dental assistants, they are under the supervision of a dentist. So we found that the dentist has the discretion in terms of saying whether or not they can perform those duties. So we really didn't need to have these candidates try to find somebody to come in and sit for the exam. We were running into situations where individuals were taking advantage of our poor candidates by charging them to be candidates. And there's just a lot of unfortunate things happening with the candidates. So it worked out nicely that we were able to address critical competencies in a written multiple choice format. The schools, which are monitored, have been doing a good job. We have our dentists providing oversight. So we were able to work with the board in removing that requirement. So the point is that you really need to be thoughtful in how you choose your format, because what we have done traditionally in the past may not necessarily be the best choice now because of changes that have happened in the testing field. So with that, let me talk a little bit now about types of questions. I'm actually going to refer you to and that's the next slide, the handout. I'm holding it up, but of course you can't see it because it's right there, but in the library, there was the State Bar of California item types, December 2019 document by Scantron that provides a really good summary of different item types. So again, I'm just going to talk a little bit about questions, types of examination questions, what we see in our boards and bureaus, and then refer you to this document if you want a more thorough discussion of different types of questions. So again, common examination type questions that you see in a licensing exam are your traditional multiple choice, where you have 4 options. One option is the key. Sometimes you'll see true, false, matching, completion, things like that. We really don't like those. Personally, we find here at Consumer Affairs, our statistics are not very robust. So we tend to stay with a traditional multiple choice, or again, what we have been doing a lot of is a scenario-based or vignette style. So I mentioned to you earlier that the Board of Behavioral Sciences and the Board of Psychology removed their oral exam requirement. And what we did instead is we introduced scenario-based or vignette style questions, where we actually have a pretty elaborate scenario of a case history client, and then we have a series of questions. Sometimes it's just one question for a scenario, or it may be several questions. But we found that we call that our clinical written exam. And we find that has had a very similar outcome in terms of the oral exam at a much more efficient way of testing. So the questions and our subject matter experts, I want to point out too, that we bring in to write these questions, we actually have we call them test specialists who are trained in test development, and they work with the subject matter experts on how to write an item for a licensure exam. Items for licensure exams are very different than the items you see on an education test, okay? That's one of the reasons why sometimes, again, people are like, well, you know, multiple choice tests are easy, you know, and they're in licensing, they shouldn't be used. We need something harder. Well, no, it's not harder. It is taking the time to develop a analytical and robust test question. That's what it's about. And so there are stages that are involved in writing these types of questions, and they undergo review and they undergo pre-testing. And yes, they can be more expensive than your traditional, but we find that by infusing those in with the traditional multiple choice test questions, we get a very strong assessment tool. And that's what many of our programs are doing right now. So they're looking at ways to enhance those written tests. The Architects Board is also another board that used to do an oral exam or more of a structured oral interview. And we have them now doing a California, they have a national exam. They also have a California exam, and they have plans. So there's actually plans that are drawn up. So we have materials for them at the exam site, and then they have to answer various questions based on the plans. And so again, as we are introduced to different technology, we're incorporating that into the process the best we can. I'm hoping at some point we'll have some 3D type testing for some of our healing art boards and things like that. Again, that will come into the future. And then, of course, finally, essay questions, which the State Bar is quite familiar with. These questions, these types of questions, as you know, can be very labor intensive to develop, to score. They're susceptible to rating error. I encourage our boards and bureaus to stay away from them. But certainly it depends on what needs to be assessed and how best to assess it. Again, most of our programs do have different other requirements for licensure, so we're able to keep the essay part out of that. Again, Pharmacy Board is an example. They used to have essay tests. They don't do that anymore now. They have a California specific, and then they have their national exam. But we moved away from the essay because we found that there were just too many issues with reliability and standardization. So essay is always a tough one, but we know with technology, we're finding some ways to do that on the computer. I personally don't have experience with that, but I can always get you research on that if you would like. The next slide talks about delivery of examinations. So you've identified what you want to test, you've developed maybe a mechanism of how you want to, what format, and then the types of questions. Interrelated to those, answering those questions, is the actual delivery of the exam. The first one here I have is the on-site paper and pencil. It's a bit antiquated. We again prefer to stay away from paper and pencil. It's extremely expensive. There's security issues. We do think it is important though as an accommodation, and if needed, certainly should be available. But the days of renting big, large auditoriums and having everybody come in and sit down and take a test with their little Scantron and filling in the bubbles, we don't want to go back there. We want to keep moving forward. So what we look at now is computer-based types of tests. And I have two examples here. One is a linear format, and that's simply where you have maybe 150 item test and everybody sees 150 items. Our programs do it in a randomized format. So if you're sitting next to somebody who happens to be taking the same test, and let me back up to, at Consumer Affairs, most of our programs, if not all, use a vendor. We have a master contract with a private vendor, and most of our programs participate in that contract. And so we have about, I think 17 test sites throughout California and another couple dozen nationally. So the great thing about this computer-based situation is our candidates can take the test Monday through Friday, pretty much any time during the day. They schedule online. Sometimes the weekends are open, it just depends. But if they're a morning person, they can take it in the morning. Many of our programs have continuous testing, so the test is always available. So with a linear format, we put a form online. Sometimes it's multiple forms. Again, we don't publicize that for each of our programs, but they go in, there's a security protocol that they follow. They take the test. A lot of them will get the results immediately, so they walk out and pretty much know if they pass the test. Computer adaptive. Some of our national exams use this. Again, I'm not as familiar with this, but it's basically a situation where candidates are presented items based upon their ability. So they kind of start, there's so many items that they must take to cover the content that needs to be tested, but they go in with kind of a medium level ability type of question. If they get it right, it gets a little harder. And the idea is that they are exposed to as few questions as possible to assess their ability. It's a great thing in terms of reducing exposure to your test questions, but you need a lot of test questions. So it's a very expensive computer-based type test format to use or delivery. But again, big fan of computer-based testing. And again, technology is improving since we first started this. There's so much more we can do than when we first started contracting for this, and we anticipate much more in the future. Another delivery methodology that I think gained a lot of attention for the pandemic. It's not necessarily new. It's been around, but not as widely used. It has certainly, again, become more popular because of the pandemic, and that is online or remote proctored. And this is typically where candidates can take an exam anywhere they want to, which is usually, at their homes on their computer. There is a vendor that will issue the exam and ensure that the appropriate software and security protocols are followed. Again, it was very popular during the pandemic. I will tell you that the majority of our boards did not do this, and we did not support it. So very different than the state bar. We had huge security concerns and did not feel that this was something that needed to be implemented because of COVID, a pandemic. We did have some national exams that did it, they were going to do it. And again, that was out of our hands per se, but we were very fortunate that our vendor that we worked with did continue doing computer-based testing. So we shut down in March. I think by April, all of our healing arts boards were able, for the most part, the ones that were using our vendor, were able to continue testing. And over the year 2020, they started opening up more and more facilities following health protocols. So they had partitions up, they limited seating, masks were worn, sanitation was done. So they worked with the individual counties, so within California, what their requirements were, as well as outside of California. So unlike some national exam programs or other professions that completely shut down, we were able to continue testing. And for the most part, our backlogs were pretty good. We had a couple professions that, struggled a little bit, but for the most part, we were able to continue testing. The next delivery is multimodal, and that's now what we're seeing with some of our programs that went to online, remote proctored, again, our national programs that are now looking at offering a computer-based, go to a test site, or you have the option of doing it at home. And I've had the opportunity to listen to some of those presentations. And again, personally, not 100% comfortable yet with that option. The examples I've seen, I would say, are not quite high stakes, where consequences of a wrong decision are as critical. The thing to keep in mind when we talk about all of these delivery mechanisms is standardization and security. You want to make sure that the candidates have a similar type of testing experience, because that goes to validity, reliability, and fairness. And then also security. We know that there's always security issues. Even with computer-based testing, we have security issues. But with online remote proctor, there are still ways to circumvent the test. Again, won't go into details, but we're not there quite yet. We think in the near future, and we are, again, working with our vendor because they have some options, but because of artificial intelligence issues and just some of the things that the State Bar has experienced, we're taking a wait and see approach. But certainly it's important to think about these types of delivery mechanisms, as well as the types of questions and all the various components of an exam when we make our decisions or recommendations. Next slide, please. I'm going to throw in just some other considerations and then some examples, and then I'll open it up to questions. As I was winding down with putting my presentation together, some random things came to mind. Again, throwing out lots of stuff to think about, but requests for accommodations. It is important to think about how those impact the measurement of the critical competencies to practice law, because sometimes an accommodation can't be granted because it is going to affect the integrity of the measurement process. It's pretty rare, but it's still important to consider when you are building an exam program. Also, frequency of examinations. This was also mentioned earlier about the twice a year. We really encourage our programs to do continuous testing and to provide those opportunities for those candidates to test. And when I say continuous testing, I don't mean that if a candidate fails a test one day, they can go in the next day and take it again. That's not how it works. What we mean is that an exam is out there and available for candidates. If they fail, they typically have to wait at least 6 months to retake the exam. Sometimes it's longer, sometimes it's shorter. It just depends on how many forms are published, because we don't want to test memorization effects. But again, it can be expensive. So the more frequent you offer an exam, typically the more expense that's involved. But again, it allows individuals to get through the licensure process, if they're qualified and competent, and get out and practice. Also, open book versus closed book. I mentioned this earlier. We have some of our programs that are looking to do an open book type of law and ethics exam, or exercise, as I prefer to call it. Again, you just really need to take a look at high stakes versus low stakes. There's nothing wrong with having an open book exercise. But if the material is really critical and important, and you want to make sure that this individual is doing it themselves, and it's not a situation where, you know, others could be providing some kind of support, then you really need to look at the delivery of that and how that's going to be implemented. Also, I'm going to add one more, but it did come up, is the reciprocity portability. This is huge with our DCA programs, more so than it has been any other time that I can remember in my time with DCA. We have a lot right now with military, how to expedite licensures for military, because we're seeing those that are licensed in other states coming to California or leaving California, and how can we facilitate that? So again, our trend has been to more toward national exams with California specific or California state exams. Not always appropriate. I'll give you an example. Board of Behavioral Sciences, they license clinical workers, marriage and family therapists, and professional clinical counselors. They use 2 national exams and then two national exams for the clinical practice, and then a state exam for their marriage and family therapists, and then state law exams for all 3. We have not, the board has not chosen to use a national exam for marriage and family therapists, because most marriage and family therapists, and probably about 75% to 80%, are licensed in California. So it's really not appropriate at this time to use a national exam. So what they're doing is they're looking at experience. If somebody's been out practicing in another state and they don't have any adverse actions or any problems, what do they need to do to get licensed in California? Just take the law and ethics exam so that they're up to date on California laws as it is regarding therapy. And so again, reciprocity is again an important consideration to keep in mind. What is really again critical for candidates and students to know as they practice, again, at that entry level. So I think that's about it. Next slide are my examples of examinations. I've touched upon a lot of these already. Again, we have hundreds of professions that we regulate and about 37 boards and bureaus. I chose the Board of Behavioral Sciences because they've gone from oral exams and multiple choice to multiple choice using a clinical vignette style. They've also moved the passing of their multiple choice law and ethics exam to earlier in the process. It's interwoven with the supervision experience. The thought was, well, if we're going to have associates out getting their supervised hours, they need to know the law. And so it's not really an entry level exam, but it is part of the process. And then they have their final clinical exam and then a national, depending upon the profession. So it's evolved. It has evolved considerably over the years. California Architects Board, again, they have multiple educational pathways that are required, and then they have a very comprehensive national exam, several components. NCARB, as they're referred to, National Council of Architectural Registration Boards, I believe. They are starting to go into technology and use some pretty neat tools. But then we also developed their California supplemental exam that has some laws, typical multiple choice, but then they have their diagrams. The Dental Board of California, they have registered dental assistants, they have dentists. Again, all kinds of different pathways to licensure. It involves education, experience. Our RDAs, again, registered dental assistants, we're doing clinical exams, no more. The dentists themselves have something called a portfolio, which you can read about in the handout, but it's putting together different types of projects and presenting them. So again, various ways that the dental board assesses their licensure of their professions. Board of Registered Nursing, I included that in here because they use a national exam. We don't do a lot of work with them, but they do computer adaptive testing. The NCLEX is their national exam. Lots of research that is done on that exam. So I included them. We will be at some point doing what we call an audit of their national exam. We haven't done one in quite some time. Again, one of the nice pieces of Business and Professions Code Section 139, that not only does it require our boards and bureaus to report annually, it also requires them to take a look, an objective and neutral look at their national exam programs that are being used. And so they will often contract with us, OPS, and we will evaluate their exam according to those standards that were mentioned in prior presentations and mine as well, to ensure that they meet those standards. With consumer affairs, we're very big on transparency, and it's very important that not only are nice little pamphlets and handouts provided, but we are actually able to delve into really how they develop their exams and validate them and ensure that the candidates are being treated fairly. And so we will have the pleasure of doing that with NCLEX soon. We've done that with the dental board's exams, Architects Board, Board of Behavioral Sciences, and many others. But we do really pride ourselves in educating the board members, stakeholders, constituents, the legislature, because what you're doing right now with the state bar, taking a look at it, is really a great thing to do. And it's, again, we have to balance consumer protection, but we also have to make sure that we're fair. And that's a really hard thing to do. But by having these conversations and doing this research, we can make a really good attempt at keeping those balanced. So with that, I'll open it up to questions that you may have.
Thank you so much, Dr. Montes. That was very informative and helpful. It looks like we have questions, 3 questions so far. Jackie Gardina.
Thank you, Tracy. That was really helpful. One question I have as it relates to all the tests that your office oversees, so that not just the bar exam piece. I was really struck by Ron's statistics regarding age. We didn't get to see disaggregation of pass rates on the bar exam related to age. We did as it relates to race and ethnicity. When I think about closed book versus open book exams, or having access to some kind of information, and I think about, and I will only speak for myself, that certainly my memory is not what it was when I took a bar exam originally right out of law school. Has any of the other licensing exams looked at age, closed book, and fairness questions?
They have not, that I am aware of. And I will share with you that for the most part, our boards and bureaus are prevented from asking demographic information. There's actually a couple codes. And so when they do ask for it, it has to be done in a voluntary manner. And we have to be very sensitive of when that is asked in the licensure process, because we don't want it to be somehow implied that it's used to make a decision. I will tell you that we are working to gather that information, especially at the practice analysis level. We also collect it in a voluntary manner with our subject matter experts, because for obvious reasons, we'd like to know, how our exams and our process impacts, different demographics. So to answer your question, as far as I know, that has not been done, but I will tell you just in my experience, and this goes to reciprocity, is we find that individuals who have been licensed in other states that come in and take our exam usually fail it. And it's not because they're not good clinicians, it's because they're so far removed from that entry level. We also see that same pattern where we have pathways of education versus on the job. So if somebody's been trained on the job, they tend to know a much narrower scope, but much deeper. Whereas if they come in on an educational pathway, it's a much general entry level type of knowledge, but it's not as deep. So we definitely see some patterns. And we're trying to use that data to help us, but we don't have a lot of firm statistics on demographics.
Thanks. I have two other quick questions. One is, are there any of the other professions that you oversee that have exams at different places in their educational experience? So they might take an initial exam at the end of their first year and then a more advanced exam or a different exam later in their educational experience?
I believe some of our national programs do that. I'd have to do some research and get back to you. I will tell you again, we tend to discourage that because what we say is for a licensing exam, it is entry level. You should do everything you need to get to entry level, and then you take that final exam. So even when Board of Behavioral Sciences moved their law and ethics exam, we were very clear that, okay, the questions are not at the same level that you would be assessing at the end of supervision because they're not there yet. So we just want to make sure that we don't maybe create more of an education kind of pathway where after you master this piece, you take an exam, this piece, you take an exam. We really try to emphasize the individual is preparing for the totality of the profession. So you do everything you need and then you take your exam.
Okay, thanks. Just
You're welcome.
one other quick question related to the simulated real situation items that you listed on the sheet. Appreciate that. I know that AR and VR are becoming much more of a presence in the educational setting. Have they moved into the licensing setting yet in terms of being used in, to create simulated experiences for licensing purposes?
Yeah, to some degree they are. Mhm.
Anyone in California yet using it or not yet?
Again, not that I'm familiar with in our programs.
Okay, thank you.
Thank you, Neil.
Actually, I think Donna was ahead of me.
Oh, okay, thank you. Donna?
Thank you, Justice Guerrero, and I apologize that I've had to be in and out a little bit today.
That's okay.
Tracy, you and I know each other, but for the benefit of the rest of the group, I'm Donna Hershkowitz. I'm the interim executive director of the State Bar, at least for the next week. And then I'll return to my role as chief of programs. I'm really excited about the opportunities that this working group presents us to be creative and innovative and think very differently about the bar exam than we have in the past, and really open our minds to different ways of doing things. And so Tracy, your presentation sparked a few questions for me. So first, thinking about the continuous testing, how do you prevent the exposure of test questions? How do you limit the security risks? And is that related to the types of questions? Like, are essay questions frowned upon in continuous testing environments? Like, how do you put those elements together to ensure you're not endangering the security of the test?
Right. So again, we use multiple choice test questions. We make sure that they're written primarily at what we would say an analysis or application level. So they're not just one line question. You have to be thoughtful in how you think about them. They come in a random order so that, again, if somebody's sitting next to you, they're not going to get the same, questions. We also, watch the time. We have proctors that monitor it, sign security agreements, things like that. They're only allowed to take that particular form of the exam. So we do, have different forms that will have those core questions, for equating and things like that, but we do add other questions. In our programs where we have issues with exam subversion, they can't go back to prior questions. So remember how I said one of the testing strategies is to look in, other questions for answers. Well, we have, for example, the Board of Pharmacy. When you sit down and take their exam, you can't go backwards. You just have to answer the question and move on. And so we find that by doing that, and then sometimes we have a survey at the end that introduces some interference in the memorization process. We also typically don't allow notes. So there's a number of of strategies that we use to ensure security to the best we can. Now, that doesn't mean that we don't find notes in the bathroom. It doesn't mean that we haven't had situations with cameras and things like that. The security procedures have gotten tighter and tighter as far as what you're wearing and what you can bring into the testing environment. We're trying our best to stay one step ahead, but the idea with continuous testing is that that exam is available for candidates at their convenience while still maintaining the integrity of the assessment process. I will also add with pharmacy, they used to be continuous, and because of not too long ago, their exam security breach issue, they've gone back to only offering it so many times a year. So again, you know, we have to evaluate. And I guess that's one thing I want to emphasize real quick is that exam validation, we call it cyclic. It never ends. It's not one exam you're developing or one process. You're always evaluating and making changes and being responsive. Yes, it's expensive to do that, but that's again how you stay up to date and be responsive to the needs of what's going on at that particular time.
And one more question. For the computer adaptive testing, which I just love the concept of, I'm assuming that requires also the use of multiple choice or true false questions. Anything more than that would be difficult to sort of ascertain the correctness of it immediately.
Again, I don't have personal experience with this. Happy to do some more research, but what I'm familiar with is like a multiple choice test. Yes, because you've got to have a ginormous bank of test questions that you're constantly feeding into that process. The other thing with computer adaptive testing, one of the reasons why we aren't using it is because those items really can't change. Once you write a test question, it needs to stay that way because it has statistics attached to it. At Consumer Affairs, we make a lot of modifications to our test questions because a good test question can be worth hundreds, if not thousands of dollars, which is why we don't encourage publishing too many practice items, because we'd rather take a question and modify it or revise it and be able to use it rather than just start from scratch.
Great, thank you.
Thank you, Donna. Neil?
I was wondering whether the department tracks data concerning performance on some of these exams against complaint outcomes. And if so, is there a particular board/exam that may highlight a correlation between the two?
We don't. We do evaluate performance data of the exam overall and the item, but we don't attach it to candidates.
Okay.
So you can go on the board's websites, obviously, and see pass rates of the various exams, and then the information pertaining to the specific exams and the test items is confidential. But again, we have to be really careful about attaching certain things to people and how that's tracked.
Okay.
Personally, I would love that. I mean, to me, that would be more construct related validation or criterion where you could do some long-term studies that, oh, this is how this group or these individuals did on the exam, and this is how they went out in terms of enforcement actions, but we don't have that.
Got it. Thanks.
Thank you. Thank you again for the presentation. Before we discuss next steps, I did want to provide an opportunity, I don't think that we did, or I did, for questions from the members on the California Attorney Practice analysis presentation, if there were any questions for the presenters. I think they're still here. Yes, Susan?
Thank you. I'm not sure which of the presenters might know, but one concern I had about both the national conference data and about the California specific data on what lawyers are actually doing is I remain very concerned about the self-selected nature of who decided to participate in those events. And I think a lot of lawyers, while invited, probably thought too busy, can't do it, and that we may not have data that is very representative there. And I've harbored that concern, and I've looked through the reports and materials, and I know that it's been statistically found to be valid, but I wonder if someone could speak to that a little bit.
Really good question, Susan. They do self-select. We invited 63,300 attorneys to participate in the traditional survey and also in the experience sampling method. Those who were willing for a 1-hour CLE credit to complete the survey were encouraged to do so. A lot of people did not. And there might be something pretty systematic about as a difference between people who chose to complete the survey and people who chose not to complete the survey. The general thought about it is that with the larger the sample size, the larger the responding group is, the more fidelity there is to the actual perceptions about practice. It's a limitation of all survey-based research. And so you raise a good and critical point.
Thank you. Were there any other questions? At this point, we are at the closing time for our meeting, but we wanted to just quickly touch upon possible next steps. Amy and myself will be doing that. There's so much that we've covered, and I wanted to thank all of you for your excellent presentations once again, and for all of your participation and thought-provoking questions. It's a little bit difficult from my perspective to determine where to go from here for some of the reasons that we've discussed. A lot of it will depend on some threshold questions, whether to go forward with the bar examination and also whether to go forward with the uniform bar examination. And given their timing differs, it's a little bit, it's difficult to, in terms of sequencing of our decision points. I thought what would be helpful is if I could get your thoughts as to whether there are certain areas or certain materials or studies that you feel you would like to review more closely, or additional speakers or subject matter experts. And then maybe we could have a brainstorming session about possible alternatives and sort of a range of options that we could consider, a brainstorming session to identify those different options to then look into in more detail, ranging from, a more extreme to a less extreme version of alternatives. But I'd like to first just open it up to get your thoughts on what you would like to see us accomplishing during the next few months. And I know it's been a long day, but if there's anyone who would be willing to share. Yes, thank you. Looks like, I'm not sure who was first, Natalie or Tracy? And also Ryan.
I think I was. So it's not so much what I'd like to accomplish or like for us to accomplish, but to your first part, which was, is there any additional information or other speakers we could possibly hear from? I thought the report out of New York was informative. I would love to hear more about someone that was familiar with producing that report and hearing New York's experience with the UBE, especially since they're now considering possibly doing something other than the UBE.
Thank you. That would be very helpful. And you have your hand up still, but I don't know if you're done. Okay, I'm sorry. Tracy and Ryan, I'm not sure, again, if it's based on who's on the left side or not, but let's go in the order of Tracy, Ryan, and then Susan.
Okay, I would be interested in having a more in-depth discussion about the findings from the practice analysis and really what should be assessed at some point, because I think that would then help with decisions about whether it's open book, closed book, whether it's a test, whether it's, you know, more of a national exam or California specific. But for me, again, not being an attorney, I see lists of things, but there's not a lot of context. And so having a better idea of what this knowledge and skill base, I think would be helpful, because it's
Okay, so
a lot of information to
more
assess.
on, I'm sorry, more on the 8 topics and the 6 skill sets. You'd like more detailed discussion of what they each entail?
Please.
Okay, thank you. And Ryan and Susan and Karen?
Yes, really quickly. So the UBE presentation, frankly, gave me a lot more questions than answers. I mean, there were a lot of promises and colorful words and hopeful analysis, but the fact is that we don't actually have a product that we could really consider to adopt for California. And we won't have one probably until long after this Blue Ribbon Commission is concluded. And frankly, I'm really concerned about what they're going to do with the MBE under the assumption that they're a business and they're trying to increase market share, which is California. Are they going to connect that with some other portion of the test to provide an all or nothing situation? Again, that's just speculation, but those are my concerns. Thank you.
Thank you, Ryan. Susan and then Karen.
I agree with Natalie that it would help to have, I mean, we had great information today about the exam. I've written a book on how to pass the California bar exam, and I learned some things today. And I want to thank everybody for great presentations, but I would like to see presentations on non-exam alternatives. I'd like to hear from a diploma privileged jurisdiction and somebody who's an expert in that. I would like to hear from some equal experts in non-exam alternatives so that we could really have this kind of full discussion we had today about exams on non-exam alternatives.
Thank you, Susan. Karen? Karen, I'm sorry, you're on mute, I think.
Of course I am, 2021. So I have, my first question is just a data follow-up question from the first presentation, and it may just be my lack of familiarity, but in terms of test results over time, whether by demographic cohort or just in general, are the results evenly distributed? I'd love to know just more about this, whether the results are evenly distributed across some kind of performance curve, or whether there's sort of natural breaks that relate to the cut points or not. For instance, is it 1% of the test takers end up within, a 1.5 points of the cut, or is it 5% of them or 10% of them? Are there natural performance bands that could lead us down at least one path for reforming how we think about scoring and pass rates or something like that? I feel very unsteady in understanding exactly how the test performs today. I'd love to know more about the sort of clinical side of what makes a good test for the kinds of skills and assessments we're trying to establish. So for instance, when I think of a lot of standardized testing, I think about 2 things. One, that they're fashioned as aptitude tests, and we're not really using that word. And I think we're not using that word on purpose. And I'd like to make sure that we have a really clear definition around what we're not trying to do, or just so we don't sort of slide into that. Another, and this is with all respect to the people who are teaching how to take this test, what kinds of, do we want this to be a kind of a test that you can completely study for and pass, or is this the sort of test that should be skewed equally for sort of for experience, for the more experiential part of it, because that will also start to inform format, security questions, how appropriate technology is, and certain kinds of end arounds or workarounds to whatever we might design. So I'm still missing some of the scaffolding, I think, that would give me the guidance to start progressing down any particular path, if that makes sense.
Yes, it does. Thank you. I'm jotting down all of your thoughts, and I'll go next in line to Mylin.
Thanks. And I will admit to feeling a little overwhelmed with all of the information that we were given today with the, testing, scoring, grading, all of the mechanisms. And so I don't know if I missed something, but I didn't hear much focus beyond the statistics on the racial disparities of the current California bar. What do we know about which testing mechanisms are the most racially equitable, so that we can move in that direction? Is there a jurisdiction or a study or something that can tell us where to go, what is working or what is not working as much?
Thank you. Dr. Henderson?
Thank you. I think that it would be really helpful to all of us to take a look at the construct statement that the CAPA working group developed as part of its consideration of the findings from the study. A construct statement serves as a statement of purpose. It defines what you're trying to measure. And until we understand what we want the test to do, it's going to be really tough to figure out what kinds of questions to use, what kinds of testing formats we should consider. Getting that statement of purpose in front of everybody and understood, I think, will be really instrumental in making progress.
Thank you. Next, Jackie, Emily, and then Alex.
Yeah,
Oh, I'm sorry. I'm maybe getting the order wrong. And then we also have Judge Reeser and Ryan. Okay, so let's start, I'm sorry, with Jackie next.
Thank you. In December of 2020, a report was released called Building a Better Bar, and it might be interesting to bring Debbie Merritt in to see whether or not she could speak to that report and the findings. And I think Joan Howarth would be another great addition. She's literally writing a book on attorney licensing, and it would be, I think, interesting to get her insights as well. She's written a lot on a variety of different licensing options.
Thank you. I'm not sure if it was in the materials, but I have seen that, and I'll follow up on the second name that you mentioned with you. I have the author's name, so I'll follow up on the second one. Emily is next, I believe.
Thank you. My just suggestion on process is that the next two meetings be more, if we can, be more experts giving us information, and then also having a discussion, as I think Susan mentioned, of what if we don't have a bar exam, because I do think that's a threshold discussion to the other charge or pieces of the charge for this commission. So that would be, I don't know if we need more than two meetings, but that would be my preference, rather than it looked like we were breaking up into subcommittees. But I do think that the next two meetings, it would be good to have everybody together hearing the same information and maybe brainstorming about what, if we get to it, what alternatives could be instead of a bar exam.
Thank you. Judge Reeser?
I would actually like to hear more about need in the public interest and underrepresented and non-English speaking sectors. I also like a follow-up on the, there was a comment about racial and ethnic disparities. I'd like to know about testing results there, which could reflect, historic biases. And I also would like to know California's experience in our apprenticeship program, because I too would like a strong consideration of bar exam alternatives.
Thank you. Ryan?
Yes, thank you. I think Alex was before me.
I'm
Alex.
sorry, you guys keep getting switched around on my end, but Alex, then Ryan, then Dr. Henderson.
One of our key missions is to really understand and decide on, whether and what changes to make to this California bar exam. And, to know what changes we have to make, I think we need to understand the impact of each aspect of the exam on the overall competency in practicing law. This means, this probably means that we have to look into studies or any empirical findings in Nevada or Louisiana on how not having, for example, an NBE section impacts positively or negatively on legal practice in those states, or understand whether hour-long essays truly test doctrinal knowledge and skill of a competent lawyer. So I think it would be useful, as much as I love all the speakers, I'm a doer rather than a listener. So I think it would be useful for the commission to brainstorm on all our options and study and debate on the strength and the weakness of each model, and then be able to make stepwise decisions as to what will or what will not work. Until we have a working model, I think right now we're just trying to understand how things come together. But essentially, and at the end, I think to truly understand whether we need to make alternative or to stick with the current exam, I think we need to debate and we need to come up with models so we can take incremental studies and decisions towards the end goal.
Thank you, Alex. Ryan?
Yes, I want to second what Alex said about having a working model and what James said about having a statement of purpose, core value, mission statement, call it what you want, but we definitely need that to work off of. And what I would like to suggest is that we have folks that have done what we're doing now or in the process of doing that come in and present. Like, for example, Chancellor David Fakeman over at UC Hastings is involved with the state of Nevada on assessing their situation. And I forgot the name of the study, but I did send some information into staff, and they are apprised of a lot more information because of their status in Nevada than we are and our state bar in California. I think they would have a lot of insights to give us on the decisions that they're making or the issues that they're seeing to model the conclusions that they're going to make. And also the state of New York, I think they might have finished their analysis. I'm not entirely sure, but I mean, someone from New York might be able to speak to the decisions they made and why with respect to their bar examination. And those type of considerations could help inform us in the decisions that we have to make as a commission.
Thank you, Ryan. I'm going to actually go to Ona. I think I skipped you, Ona.
Thank you very much. I want to echo a few things that have been said, including feeling a little bit overwhelmed, but mostly I wanted to pick up on some of the comments that Judge Reeser made and others have sort of been alluding to. And I think that, one of the concerns that certainly I had coming into this and that I know have been expressed by others, certainly in my, universe, it has to do with the sort of racial disparity in passing the bar exam as it currently exists. And toward that end, I don't want to get too far afield or get too off topic, but I do think it would be interesting and worthwhile to really sort of dig into that, because I think I was really struck by I think it's Ron B's slide where he had a depiction of the variability by demographic group, and the least amount of variability was amongst white males, which tells you something to me about what's actually being tested. And I'd just like to, I don't know that we can get out of it or around it or avoid it altogether, but I'd like to understand that better. And I know that there is in fact research that's been done on sort of performance and sort of the psychology around performance, particularly by people of color and other underrepresented folks on standardized tests. And so, I don't know how much time would be appropriate to dedicate to that, but I think that really kind of understanding what underlies those differentials in performance that, by the way, are not unique to the bar exam, right? We see them across all sorts of standardized tests. I'd like to understand that a little bit better, at least, sort of at the level that we can. And then just selfishly appreciate the request to get these materials because I feel like I kind of need to do today all over again to really understand everything. So these were great presentations, though, really helpful, and I'm excited to move forward.
Thank you very much, Ona. Dr. Henderson and then Natalie.
I actually didn't intend to raise my hand a second time, so.
Okay, thank you.
Thanks.
And Natalie?
I would also like to hear from the State Bar, because I think one thing that really dawned on me today is that no matter what, there will be a new bar exam coming to California in light of the MBE going away. That will drastically change no matter what we decide what the bar exam will look like in a couple of years. So maybe hearing from the State Bar on any work they've already done. Is California even in a position to replace something like the MBE with its own MBE, or just any work that has already been done or looked into by the State Bar?
Thank you, Natalie. I think those are all the questions. Amy, I'm not sure if you had any additional thoughts or anyone else.
No, I think these are great suggestions, and I think that we could definitely prepare panels of speakers. I think we have, forecasted that some of these would come up, such as the apprenticeship programs, talking to other jurisdictions with that model in place. So we have a lot of thoughts here that we could plan around for our next couple of meetings. Sorry, my voice is going.
Oh, thank you. No, I'm sorry. It's been a long day, I know, and it was echoed by a few of you of feeling just overwhelmed with the volume of information. You're not alone, and it does help, I think, to have the materials in writing. So we'll definitely get those out to everybody. The presentations were fabulous, and everyone who worked so hard in preparing for today's meeting, thank you all and each of you, as well as the members of the public who submitted comments both in writing and orally here today. Those were helpful as well. We've concluded with all of the items on the agenda. Unless there's anything else, is there any more business from anybody? It doesn't appear to be the case. So at this point, we're going to go ahead and adjourn today's meeting. And again, thank you all very much.